Any mention?
My lord, I like to mention one matter for tomorrow, my lord. There is some urgency in this case. I am getting this matter filed today.
For motion?
Yes, my lord. Please, Lordship. I beg to mention item number 10 and 11. As per the order dated 3/10/2024, I supposed to bring on some record. I just need some time to file the additional affidavit to bring on record because there is order, Lordship.
May it please your Lordship.
What you were supposed to bring on record?
Because there is order that this criminal petition was filed on September 31st September 2024, and after that there was an order passed by this High Court of Meghalaya, another bench. It was passed on 3/0/10/2024. So I want to bring out because it has some bearing on that in this particular case, because what happened, there is a judgment, clear judgment says that locality is mandatory to make a party, but in this particular case they have not a party as a necessary party to the locality. So I just want to bring on record.
My lord, if I may submit, I am appearing in item number 10, my lords. This matter has been pending. On the first day itself, your lordship had observed that there is only a legal issue involved in this matter. As to whether the Meghalaya Local Yukta had jurisdiction to proceed in this matter or not. Now, my lords, I do not understand what my friend wants to bring on record, my lords. In the last proceedings, he said that he wants to make Meghalaya Local Yukta a party.
He wants to say that
all pleadings are complete. The report of the Loka Yukta is already before the special court.
Lordship,
The
they
were
very much aware.
I don't see.
They were
any
very much
further
aware of this
indulgence being
that
granted to
order which I am
the
bringing.
respondent.
One by one, please wait. See, if you
Lordship will not.
speak together,
Lordship.
now was that opportunity afforded to you?
Yes,
by
yes,
last
yes.
order?
Lordship, the
They
court
are
is
on
not
the last occasion. They also was appeared, Lordship. This is their order.
What is
They
the
are-
last order passed here?
There's order 31st May 2024.
In this case?
That, not in this other bench, because they file a
No, what is the order passed
delay.
here in this case? What is the last
Yes,
order?
yes, that order was there on here also. 3/10/2024. It says that
He can't really hear him.
there was a affect short, but actually it's not affect short. But instead of hearing the present matter need to be placed before this honorable court and pray for grant of some time.
How long you will take to file?
You can give me the last chance because I will file
How
it.
long you will take? Just tell us.
Lordship, if kindly accommodate me within 2 weeks, I'll file it, Lordship, without fail.
Yes, you do it. But then that will be.
Lordship, if I fail, then this will be should not be allowed.
Should be last and final chance for him.
Yes, Mr. Pandey, we'll see it after 2 weeks. We'll give him another 2 weeks and we'll just see.
Yes, Lordship. Item number 10 and 11 is the same.
Yeah, both. Yes,
Court is not audible, my lord. So, yes.
Anyway, you just convey it. Yeah. Yes. As requested by the learned counsel for the petition, and dismiss matter after 2 weeks. Yes.
Deep developments, my lord.
My lords, I just request that let it be, my lords, fixed for final hearing on the next date.
It is in the hearing list only.
Yes, my lords, and further adjournments may not be granted
We'll
in
see,
this matter,
we'll
my lords,
see.
because trial is proceeding, my lords.
We'll
We
see
are
it, let the pleading be
bound to
complete. Yes.
May it please your Lordship. Your Lordship, I beg to make a mention of item number 12, 13 and 14, your Lordship. This
Yes.
is connected matter, your Lordship. I'm praying for 3 weeks time, your Lordship.
Why?
Your Lordship, the similar subject matter is pending before the Supreme Court, your Lordship, as per the instructions, your Lordship.
No, objection.
Yes. This is also. At the request of the learned counsel for the petition, and dismiss matter after 2 weeks.
3 weeks, your
3
Lordship.
weeks. 3 weeks. It's 12, 13 and 14.
Yes, your Lordship. I will oblige you, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 19, Your Lordship. I pray if Your Lordship can have this matter after 2 weeks, Your Lordship.
I have no objection.
Same order. After 2 weeks, item 19. Yes.
Deeply obliged.
May I please your Lordship?
Yes.
Lordship, I beg to mention item number 7 of today's list. Lordship, due to some medical issues, my senior Mr. P.P. Potbo could not appear today, Lordship. Matter will be taken up after 3 weeks, Lordship.
No objections, Lordship. Your MS. Your what's your name?
I, Hussein, Lordship.
Yes, you just say MS. MS I Hussein, learned counsel for the petitioner. Praise for grant of some time this matter. Mr. Karvanlang, learned. Your additional synergy. Watch. Has no objection. Prayer alert. List after 3 weeks. Yes. Much obliged.
May I please, Your Lordship? I beg to mention item number 18, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship. Personal difficulty of the conducting counsel, Your Lordship.
No objections, Lordship.
This also had the request of the petitioner. This is matter after 2 weeks. Yes.
Highly obliged, Your Lordship.
Much obliged, Lordship.
May it please, Your Lordship, I beg to make a mention of item number 3. Lordship, my senior counsel is having some medical emergencies at home. I humbly pray this matter may be listened.
Madam, this is a 2015 matter. This service matter.
Lordship.
Service matter.
Lordship.
Dismissal from service.
Lordship.
When do you want it?
After 2 weeks, Lordship.
MS so-and-so, learned counsel. Appearing on behalf of Mr. K. Paul, learned senior counsel for the petitioner. Submits. Praise for not submits, praise for grant of some time. On the ground that the senior counsel is indisposed. Stop. The prayer has not been opposed by the learned additional senior GA for the state respondent. Prayer alert. List after 2 weeks. Yes.
Lordship, similar prayer for item number 4.
Item number 4. Who is the other side? Item number 4. See, madam, these are all old matters. You see, next time make sure these matters are taken up. Here also just make the same thing. You are there, Mr. Karwanla. Here same order, and just you record the name of all those things. Please make sure it's enough adjournments in those matters. Yes.
Much obliged.
Same order.
Your Lordship, I beg to make a mention of item number 20.
The last item.
Yes, Your Lordship.
Yes.
Your Lordship, if the matter may kindly be taken up after 3 weeks. We've applied for certain documents in the lower court, so we're waiting for that.
No objection.
What bearing those documents have in this matter? Just as requested by the learned counsel, the petitioner list after 3 weeks. Yes.
May I please, Lordship, I beg to mention item number 15.
Yes.
No objection, Your Lordship.
Wait, let the prayer come. Prayer has not come till now. We do not know. Might be praying for upgradation also. Yes.
May this matter take up after 2 weeks, Lordship.
You are appearing for?
Respondent number 2, Lordship.
You are private respondent?
Yes, Lordship.
Your state.
State, Lordship.
What is the matter about?
Lordship, this is an application for recalling of the witness under section 311 CRPC, Your Lordship.
You filed an application for recalling witness.
Yes, Your Lordship.
It was rejected.
Yes, Your
So
Lordship.
against that you have come.
Yes, Your Lordship.
So why state is a part? State is what?
It is a party here in Lordship because it's the order of the court that has been challenged before this honorable court.
Otherwise, you are not a contesting party.
No,
What is
Lordship.
what is the matter about? What is the case about? What is the dispute involved?
It's a POXO
POXO matter, Your Lordship.
It's a POXO matter. How come a private individual files a case? This is for quashing, or she says 311.
Lordship, because they have their
pray that this matter may come up after 2 weeks, Lordship. On account of personal difficulty, we are unable to take up.
Your Lordship, if this matter may come up after 1 week, there's some urgency.
2 weeks? 2 weeks, Lordship. Pray for 2 weeks.
Yes, as per provide Mr. J. Thawal Arnett, GF, this is matter after 2 weeks. Yes.
All right. Close to Lordship.
May it please, Lordship.
Yes.
Lordship, I beg to mention under item number 8, Lordship.
Yes.
Lordship, if this matter may come up after 2 weeks, Lordship.
So, Balpakram matter. I'm filing the synopsis, my lord. My synopsis are ready. Anyway, we can take on record the synopsis and allow to argue on
What is the purpose if it is not taken up? If we keep the synopsis, you can submit it on the next day. Where is Mr. Shen?
Lordship, he's stuck in traffic, Lordship.
This also has requested by the requested on behalf of the state respondents. This is matter after 2 weeks. Yes.
Okay.
May
Item
I
number
please, Your
1.
Lordship? May I please, Your
Yes.
Lordship? Your Lordship, I beg to mention item number 6, Your Lordship. I humbly pray that this matter be taken up for 2 weeks, Your Lordship.
Item 6.
Yes, Your Lordship.
Yes, Mr. Hazarika. Is that Nakma matter?
Yes, Your Lordship.
No matter. This one is pending since from 2017 matter.
You are appearing for?
I proved a private respondent.
You are opposing to prayer made by the district council. If you have objection, we will not adjourn the matter.
Maybe they are having difficulties. No objection.
Yes, Mr. Hazarika.
They come after a week, my lord. After that,
Yes.
may not given any time.
After a week, Your Lordship.
The request meet on the respondent number.
Yes, fine.
In this
1 to
matter
3.
after
1 to 3. GHDC.
this is matter after 1 week. Yes.
Deep leverage.
Yes, paper book.
My lord, it is ready. So do
I'm appearing for the respondent number 1 and 2, Lordship, in this matter. The notice has been issued on respondent number 3, and the service report is awaited.
I think this thing ID card has come.
Yes, Your Lordship.
Service sub notice.
Yet to serve.
This is come. This is okay. This is deleted. So
Yes,
can you
please,
just give it like this thing? That is better. This way it's confusion. Yes. No appearance for respondent number 3.
Nobody
Respondent
is
number 3.
appearing here.
It appears that has been served. What is the matter about?
Quashing.
You're seeking
482.
quashing of
Quashing of FIR, Your Lordship.
alleging what? It's in connection with what crime?
Accident.
Accident,
Motor
Your Lordship.
accident.
Motor accident.
Yes.
Lordship, let the private respondent also appear.
Private announcement is not there anyway. Just say office note dated. 18/10/2024 indicates that the respondent number 2 has been served. However, there is no appearance on behalf of the said respondent before this court. As prayed for by the parties, release this matter after 2 weeks to await the appearance of the respondent number 3.
Highly opposed, Your Lordship. Hearing item number 5.
Number 3 before this court. Huh? Yes. Yes.
My lord, I seek some time. I seek some time for this case.
Why you did not make me mention at the time of mentioning?
My lord, I have a small submissions to make also. During the meantime, can let the state supply the order of the record which they have stated in the last order.
What is the order?
On 27th, 9th.
Instruction. Their instruction.
Yes, instruction.
They are not supposed to pass the instruction until and unless it is required. It is told by the court. If you first let us see what is the instruction. If you find that it is necessary, then only we will tell them. Yes.
Because we wanted to check some of.
See, instruction until and unless, so long it is asked to be put by an affidavit, that remains a privileged communication. You cannot demand it. Okay, we will just simply adjourn it. But then when this is also 2016 matter.
Yes, my lord.
Yes. So when you will be ready to take up the matter?
Maybe the next time. Because we are waiting for that record to check some of the.
Yes, we'll wait after 2 weeks then. Yes. Miss So-and-so, Learned Counsel. SR Marak.
Yes, my lord.
Learned Counsel appearing for the petitioner. Case for adjournment of the matter by 2 weeks. On the ground that the conducted counsel is not available. Stop. Mr. Hajarika. Learned GA has no objection. Prayer allowed. Mr. Proceedings. Yes.
Item number 9.
Yes.
Yes, sir, application suspension of sentence will be.
Okay. Oh, yes. On the illness.
I have received instructions, my lord.
Yes.
Well, there is an alternative remedy under the BSF Act, my lord.
Is it? So you would like to file an objection in this matter? Or?
My lord, I'll just point out the provisions of law.
Because Mr. Gautam must know what is your objection.
My lord, what the BSF says, my lord, filing objection may
tell your officer to sit down. He senses there's a problem.
May involve some time, my lord. So I'll just place, if my friend is satisfied, he can withdraw and file an application before the appropriate authority.
If there is any alternative remedy, then definitely you can avail it.
But that should have been availed.
This is one court, you see, like basically this court, if any alternative remedy is available, the court will not entertain. That is what.
So let him place.
See,
yes. I'll also argue.
Yes, yes. And where is your application? What is that application number?
It's in this case
1 of
2024.
And you just Dr. Mojiga, before you just say, just let us see what is the case. What is his case?
Well, my case basically is, my lord, I have challenged the finding.
No, here in this miscase.
No, the miscase is only, my lord, that my father is about to die. I have a application.
Your father is about to die. How do you know that?
My lord,
you can say that he is serious, but then.
Well, this is what the doctor himself has said, my lord, that it may be a terminal event.
Doctor says that he will die anytime.
My lord, that is why he was sent back. Doctors have raised their hands.
Where is it? Where is that certificate?
My lord, lordship will come to the type copies at page 8. If I may read, my lord, this is regarding Mr. So-and-so, aged about last page of my application, my lord.
Yes.
Aged about 70, he is under my treatment since last 1 year. He is suffering from severe Parkinson, severe dementia. He is advised palliative care at home with relative care 24/7. He is advised to have his dear and loved ones to be around him at the stage of his illness, maybe terminal event.
So but then nobody can say that definitely what.
But that to nobody can say, my lord. Of course, well, nobody can say.
But
this
you
is
should not
what
say that. You can say that he is in serious condition. You should not say that he.
Well, I take my
Anyway,
my
whatever.
submission back, I say is in serious
No,
condition.
see, whatever sounds sweet, that should be used.
My lord, obviously, my lord. But
yes.
The situation is such that, my lord, the way I have been, whatever I have been, my lord, instruction has been given to me. Now, my lord, my case basically, my lord, on merits also, on two things, my lord, since learned officer is also
let
here.
us be confined to this application first.
For this
if
application,
you say that you will not press this application, then we will come.
I will press this application, my lord.
Then
I will press
then it's
this
okay. Let us see what is the then, Dr. Majika, what is the alternative remedy?
My lord, BSF Act. BSF.
Have you seen this thing?
Well, I am not aware of this one.
Oh,
You should have been done that at the time, my lord. When
Section 78, my lord.
But then what is the reason of your objection, Dr. Majika? Otherwise,
my lord,
if it
on
is
merit,
genuine.
On merit, we may not have, my lord. My lord, there are two aspects. I'll just point out, my lord. Section 78 says, my lord, application of act during term of sentence.
Yes.
When a person subject to this act is sentenced by a security force court to imprisonment, this act shall apply to him during the term of his sentence, though he is dismissed from service or has otherwise ceased to be subject to this act, and may be kept, removed, imprisoned, and punished as he continues to be subject to this act.
Then?
Sentence to death is not applicable, my lord. So, my lord, basically it says, while the period he is serving his sentence, my lord, he is still subject to BSF Act.
Say, supposing this writ application, do you say that he is not a subject to this act? Whatever will be decided, that will be definitely decided by taking into consideration the provision of the act.
My lord, that is one aspect, my lord. I'll just one more provision I'll point out, my lord.
Yes, please.
128, my lord.
Just a minute, Dr. Majika. Yes, 128.
It talks about pardon remission, my lord. Well,
yes.
128 says, well, pardon remission. When any person subject to this act has been convicted by a security force court of any offence, the central government or the Director General of Police, as in the case of sentence which he could have confirmed, my lord, or which did not require confirmation, officer not below the rank of DIG within whose command such person at the time of conviction was serving, or the prescribed officer may, either with or without condition which the person sentenced accepts, pardon the person, mitigate the punishment, my lord, clause B, C is commute, and D is either with or without condition which the person sentenced accepts, release the person on parole. Now, my lord, section 130.
Come to the relevant part. Even till now, we see that there is 130 would be relevant. So why you going this way?
No, my lord,
it's not your case. Is not a case of pardon or remission. Here we are not concerned with all those things. We are just concerned with temporary release on bail. Whether there is a provision for that or not. Yes.
130 says, my lord, where a person subject to this act is sentenced by a security force court to imprisonment, the central government, the Director General, or any officer empowered to convene as General Security Force Court may suspend the sentence whether or not the offender has already been committed to prison or to force custody.
Yes.
So, my lord, the overall scheme of the act is, my lord.
Which way it says about the now? What is the question of now? Can he go and approach the Security Force Court?
Well, the DG, my lord. The power is the Director General.
No, then see, what is it? Then suspend the sentence. What is the question of he is suspending the sentence at this stage? Matter is pending here. Can he go and file an application to DG at this stage for suspending sentence?
Or
see, we are not concerned with suspension of sentence. It's totally a different thing. Do not confuse it. We are not suspending the sentence at this stage. This is a release for just certain period of time.
My lord, what parole under section 128 is more or less identical power, my lord. And there are past precedent. What officer statement, this is happening on day-to-day basis, my lord. There are several applications like this. So when somebody is sentencing, serving sentence, my lord, and he need to go in the identical circumstances.
So it means who exercises the power of parole here? The detenting authority with
the Director General, Director General or Deputy DIG.
So that is what, see, like we are not going. Why you are confusing the court to going into a sentence, suspension sentence? If you want to say that there is a parole, then definitely yes. Mr. Gautam, what is the problem in you filing an application for parole?
If he files within 1 week, we'll pass an order.
When I am before this honorable court, my lord, whether, my lord, that particular suspension of sentence I should have filed before coming to this court.
We are not going for suspension of sentence.
My lord, then today, my lord, we, like Lordship had told me on the last occasion, my lord, we will not go into the aspect of suspension of sentence. Lordship may kindly grant me temporary bail. A surety will be furnished. And
one thing, do not say the court has told you something.
No, I'm sorry, my lord.
We have not this. You cannot bind the court like that.
No, that is not my endeavor, my lord. On the last occasion,
do not try to do
some confusion between suspension of sentence and bail.
Putting the obligation on the court. This is not.
No, my lord.
Court has never advised you to do anything.
I apologize, my lord. I apologize.
You see, if at all,
my lord,
this court has said something or expressed his opinion, that is before Dr. Mojika placed those provisions before this court.
Yes.
Okay, so and there is no such order. So you cannot say that.
Learned Senior has said that these applications are being filed on a daily basis. How many applications have been filed when the petition is pending before this Honorable High Court in my learned friend?
Now, Dr. Mojika, if an application for parole is filed, how long will it take to decide?
A week? 10 days or a week, my lord. So, because there are two aspects, my lord.
10 days, 1 week. Whether he has that much time in with him.
My other doctor certificate of 14th October, my lord. I think 14th October.
Not October, it's September.
I came after 2 days.
It is, yes, 14th October. 14th October.
I came before this court on the 16th.
But then it doesn't mean that you can take another 10 days.
Well, in fact, I have an order brought from Himachal Pradesh High Court. More or less an identical situation that we were directed to file an application.
No, if you say that you will decide this application for parole within a shortest possible time, then
a week's time we will decide. But there are only two aspects. The doctor's certificate has to be verified by us, my lord, and then a report will be submitted, and thereafter it will take 1 week. So 7 plus 2, 9 days, my lord.
You have the doctor's certificate with you. You have not verified. It is there with you for 3-4 days at least.
3-4 days. We have not verified it, my lord.
You should have verified. Verification was needed, even if it is considered by this court or whether by the DG. The verification was required, and that is what. See, this is causes a human cause. We may not strictly rely on technicalities until and unless there is a bar for this court to exercise that power.
But under 226, I cannot say, my lord, this court doesn't have power, my lord. There is plenary power with this honorable court.
But that why you are raising an objection? See, just because there may be some procedure which allows him to go and approach the departmental authorities. But then, until and unless there is a specific bar, of course, we understand what you say, it is correct in law. Even now, Apex Court also repeatedly in recent years, you will find the court has said whenever there is an alternative remedy available, see, the writ petition should not be entered. Until and unless the party shows that why he cannot avail that. That is what the law is, the consistent view of the Apex Court now it seems to be appear. See, or if it infringes, you see, like any of your legal right of fundamental. Now we can understand even if we say that he has an option for applying the DG, and since you will take much longer time, in such a case, otherwise maybe this court have directed him to approach the DG, but then your process will take time, and you will be helpless if it takes time. And if any unfortunate incident, you see, like if something happens, then his basic entire purpose will be defeated.
Well, what I would submit, my lord. Well, kindly record, because this is all India affair, my lord. Because any order passed by this honorable court, so if your lordship just records my submission that alternative remedy is there, and then your lordship.
We are not saying that we will not say it is not you are supporting. We are not saying we are opposing. There is no question. You see, but then I do not know. What is the department is run by you, isn't it?
I follow your lordship.
By your officers, isn't it? Now I do not know what problem is there. So this is for the officers to take a decision. Why there is a problem to take a clear-cut stand.
No, my lord, he has not approached us, my lord. That is the whole difficulty. Had he approached us by now, maybe the order would have been passed by now.
He's lodged in Tura, his family is from Maharashtra.
What is the decision, apex court decision you have rendered this thing?
Well, as far as this is concerned, my lord, High Court's power of granting bail.
See, like bailer, what kind of bailer you can arrange?
Well, his brother-in-law is here, my lord.
He's in Shillong.
Whole family. He's here, my lord, for the last. He went back and he came back again. I think
here.
he'll be the best bailer.
What he's
Well, he's got a small business, my lord. A small electrical shop. An own relative, my lord, because I think own relative will
because
be
they will not
suitable
have
bailer.
any hand. If at all this court gives you relief now, and if your bond is to be accepted, that acceptance they will not have the hand. That is a problem. The suitability of the acceptor. So that is one thing.
My lord, the reason why, my lord, I say, my lord, this person.
You may have blind faith on your client.
Not blind faith, my lord.
But then, if you want us to have the same kind of faith,
I'll
then
give a
it
very
becomes-
logical explanation, my lord. Why, my lord, I say the person will come back. Well, this is not a criminal appeal. This is a criminal writ petition. What is under challenge is that, my lord, I have been terminated from service. Out of 7 years, I have almost served 3.5 years. My lord, I will want to know, my lord, what will be the outcome of the case, because that will have a bearing on my service. And it's not that I don't have a good case, my lord. They have not followed their own rules. Statutory rules have not been followed.
Why you have kept
The
it pending for such
post-confirmation
a
has
long
been.
time?
I'm sorry, my lord.
2022 you have filed this case, isn't it?
Yeah, my lord, because
Then why you have kept it pending? This
my lord, the problem was that, my lord, we had to prepare a paperwork. My lord, they have not bought the records of this court also. We only allowed
If you
to
wanted,
inspect.
you could have made it faster. Anyway,
Of
you
course,
see,
well, that
let
could
us
have
not
been
go
done.
into all those things because record will not support your submission. So just only thing is that this court is otherwise inclined to give you relief
Because-
considering the urgency of the
My
situation.
lord. Okay. So the anxiety that he'll flee, my lord, it is not only this sentence that is important for him, what is more important for him is his entire service, my lord. If he comes out successful here, my lord, he'll be taken back into service.
Where are the decisions you relied on that the other day?
Well, this one decision of our own High Court, where
The bail bond was accepted.
first is, my lord, the judgment of the Supreme Court, my lord, where
Yes, you refer two decisions.
Under
Yes,
the-
it is there. It is there.
well, page number 1 of my compilation, I've given a compilation.
Now you say that your brother-in-law is here, or brother is here.
My lord, brother-in-law.
Brother is here.
So I say he'll be the best surety because, my lord, he is the relative.
And where he is having shop?
In Sholapur, Maharashtra.
He's not a local bailer. You said who is here?
No, I mean, he's here, my lord. He's traveled all the way from Maharashtra, my lord. Local to, my lord, how will I find a local person over here? It'll be very difficult, my lord.
This will be quite difficult. You see, it is not a normal thing, normal bail. See, where you can say that the question of geographical discrimination and all, you can raise if local bailer.
Because, my lord, the
But
person
then
never
here
resided.
is a case, you see, like only, otherwise it is difficult. You see, this court doesn't want to.
My lord, will bind the bailer to
See,
in such a
See,
situation.
the decision of the apex court which you have relied upon, it has nothing to do with bail. There is nothing. There is no transfer of custody. The apex court
Police
passed an order,
personnel were involved.
allowed him to go out with police escort. Here it is not possible.
Yeah, it's not possible. That is not possible.
So basically, that decision doesn't help you.
Well, only to the extent that, my lord, court can exercise powers in such cases. My lord.
But
That
yes,
is, that is
this
my
court,
endeavor.
yes, we are ready to exercise. But then the thing is that, see, the problem is that you see, like you said that you do not have a local bailer also.
I'll make an endeavor to maybe, my lord, he must have some friends from the force.
Oh, we would see, like normally court should not say, but then since you are in a convict, okay, that presumption of innocence is not there with you anymore. The conditions has to be more stringent than the normal.
Yes.
That is what the problem is.
My submission is, my lord, if you have a relative, my lord, and he has his own shop and he has got his GST number and everything, my lord. So it's not easy for him to run away. We can bind him.
You see, we do not know, you see. The Registrar General has the power to accept bail.
Yes, ma'am, in such cases.
That is provided in the cycle rules also.
Well, that I am not sure, my lord, but generally this is
You
the
should have- you
all
should
high
have
courts.
checked it.
All
You
high
should have
courts
checked it.
follow this, my lord.
You see, like, should we, yes, Dr. Mojiga? Whether Registrar General has the authority, you have any idea?
This is followed by Delhi High Court also, my lord. Other high courts also.
This decision, which decision?
Yeah, my lord.
It's all
Yes,
right.
my
It's all right. Then Hard, Mr. K.C. Gautam, Learned Counsel, appearing for the petitioner, and also Dr. Majika, Learned DSJ. There is no one to assist you, Mr. You cannot appear without a junior.
Just to send a
Without junior, you are equivalent to a handicap person.
I understand that. Okay, Guru.
In my early days in practice, I was once that situation happened, and my senior for one certain, you see, like for sometimes only he was left without junior, and court did not allow him to make submission.
Sir, I'll take care.
By this application, the petitioner has made a prayer for his release on bail for a temporary period to avail him visit his ailing father. Where? Which place? At
Boom district in Maharashtra. my lord.
it is mentioned in the petition.
But it's not mentioned in the petition.
Then
I prepared the petition in just 10 minutes, my lord, that they have to send it.
should have incorporated. These are vital information. If you can could write 100 lines, why to miss that?
That day I was in that situation, my lord.
You have missed it. See, these are not good excuses.
I apologize, my lord.
At least you should say, like you should mention where you visit. Without that, how we'll know if it is not
his
your place?
in the affidavit, my lord. The applicant's address is in the affidavit.
That is all right, but then your place of visit, where you'll be visiting.
My lord, boom, my lord.
That should have been on affidavit.
My lord.
Just you have to give him the spelling and.
I will.
Okay. The Learned Counsel has placed before Learned Counsel has drawn attention of this court to a medical certificate issued by medical certificate dated 14/10/2024, wherein it has been specifically advised that the near and dear one of the ailing father of the petitioner should be around him at this stage, as it may be a terminal event. That is correct?
My lord, correct.
The Learned Counsel submits without Learned Counsel without referring to the merits of the case submits that in this urgent situation
he may be allowed to visit his further, ailing father. And in support of his contention has placed reliance on the decision of the apex court. Reported in 2021, 5 SCC, page 311. You see the name of the parties, you'll get it in page 1. And contended that in such a situation, it is permissible for this High Court to order the release of the petitioner for a short duration time on bail. Step. The Learned Counsel has further placed reliance on a decision passed by this court in, you see this page 39. Okay, you see the party's name, case number and WBC number and submitted that as per the said decision, the Registered General of this court is competent to accept the bail bond for any such release paragraph. Dr. N. Majika, done at GSGI, while opposing the prayer of the petitioner, has submitted that there is an alternative remedy available to the petitioner for redressal of his grievance, for seeking relief, not denunciation, seeking relief at this stage. Stop. The learned DSJ referred to section 78, 128, and 130 of the BSF Act, and contended that in similar situation like this, the petitioner should approach the Director General of BSF Stop. It is a submission of the DSGI that since there is alternative remedy available, the petitioner could not have approached this court by filing this instant application. Stop. He submits that application be rejected and petitioner be directed to approach the Director General of BSF for the relief which has been paid for by him in this petition. Stop. Paragraph. Having heard the learned counsel for the parties, you can sit down, Mr. Gautam. Why are you standing? You are not supposed to behave like an accused in the court. Yes, having heard the Learned Counsel of the Village, it appears on the perusal of the medical certificate dated 14/10/2024 that the father of the petitioner is seriously ill, and it is indeed an emergent situation. Stop. Though the submission has been made on behalf of the respondent, on behalf of the opposite party, or respondents, let's say respondents, comma, it appears that the approaching the Director General of BSF at this stage would take considerable longer time. Approaching BSF, approaching Director General of BSF at this stage by, don't say, by filing an application and seeking disposal of the same may take considerable period of time. Step on query being made by the court. The learned DSGI submitted that matter may take 7 to 10 days for the DG to dispose of the application of the petitioner after the same is filed. Step. In view of this situation, give a paragraph, you say in view of the situation, without going into the merits of the contention raised on behalf of the respondents, comma, it is deemed appropriate at this stage to, for how many days? Well, 2 weeks. Is it not too long? It's quite far, my lord, actually.
How long it takes to travel that place?
How it goes depends on
Flight, my lord, won't take time, but I am not sure that train will take around 2 and 3 days.
See, you are not supposed to go there for merrymaking, isn't it? You have to go and just you want to.
No, my lord, totally, sir.
Okay.
Only thing is, my lord, the distance and the time, my lord.
So we want to know the journey time. There is no disclosure about all those things. Even you have not said where you are going.
I had to.
You see, there are many deficiencies, so as to say.
Well, it's in Maharashtra, my lord. It's in one of the districts in Maharashtra. Maharashtra, if he travels by flight, then my lord, perhaps he'll reach early. But whether he can afford.
Anyway, 10 days enough. Will not give you.
I'll give me 2 more days, my lord, just in case travel time, taking that into consideration.
Any instruction, Dr. Mojika, how long it may take, the journey time?
It should not take more than 48 hours. 2 days, my lord.
2 days.
2 days going, 2 days coming, 4 days. Still
10
get
days would
6.
be enough.
10 days would be enough.
Well, from the date of his release, my lord.
It is because of your prayer the court is allowing. You see, otherwise this court is.
I'm very obliged.
It's not inclined. You see, like
I'm very obliged.
there always remains a danger. You see, releasing.
I absolutely understand. Very obliged.
Even we are not going by what Dr. Mojika's objection. Just thinking that it's a need.
Situation.
It's a need. Yes, definitely. What you said? We'll give you 10 days time. You see.
Well,
yes. It is deemed appropriate to And it is what is it? To allow the release of the petitioner temporarily for a period of 10 days on bail on his execution of a bail bond of rupees 10,000 with a surety of like amount. Now, your surety will have to. This is one thing you say. There's a problem. You see, that is the. You can arrange a local surety. We'll make it a local surety.
Local might be a little difficult now. Why I say, my lord, the relative will be a better surety, my lord, because if he does not come, my lord, then the relative will be liable. You will drag him and bring it here also, my lord. But if it is a local surety, my lord, it will be somebody who will not be that liable. So
See,
the amount
Registrar
is-
General will not be very equipped to see see the suitability of the.
Well, he has a shop, electronic shop, my lord. You can raise the surety amount also, my lord.
The amount is not a solution, you see.
No, my lord, because if we have to look for a local surety, my lord, because we don't have any local.
We can understand this court is very well aware of the fact, you see, that Krishna Iyer's judgment, the geographical disposition, see, everything is there in otherwise this court have passed some order without asking or asking for any suggestion from the learned councils. Anyway, we'll just see how much responsible you are.
I think he'll come back, my lord. That's what I can
Do not say I think, it has to.
He will come back, my lord, because he has a surety. His own brother-in-law is a surety, my lord. Had it been a local surety who is not, related to in any way, my lord.
His brother-in-law is here.
His brother-in-law has travelled here, my lord, just for this purpose.
And he doesn't have anyone from here.
No, my lord. They are from Maharashtra, my lord. He was, because of his employment, he was transferred to Tura.
From
This he has to establish that he is brother-in-law.
Even Dr. Majika or me, even we are originally not.
Now we'll have to establish that he is the brother. If he's not the brother-in-law, why will he come here?
Son, daughter is easier to establish by birth certificate or some type of brother-in-law to even to establish one.
Anyway, what we say, this is like amount, isn't it? What we say that to the satisfaction of the Registrar General of this High Court. What more precaution we can take?
My lord, two more points, my lord. He will not leave the jurisdiction of the country, my lord.
He's going to be this one.
That's one. And secondly, my lord,
yes.
After reporting, he'll file an affidavit, and this writ petition will be heard only after that.
You file an yes, definitely. That is definitely. Anyway, it is also provided that the petitioner shall not leave the jurisdiction of this country and intimate about his travel plan to the appropriate authority of the respondent
In Shillong.
in Shillong. That will, I think,
How
miss-
do in Tura.
in Shillong, no, he will go. He'll give his travel plan when he's going and by what thing he's going. I mean, like what communication he's going, and then what is his date of coming and all those things. That is to be.
But that we can. Because
You have to do it. See,
personally, even.
because you see, your client will have more confidence. We may not have that much.
My lord.
Confidence. What you said? In the emergency country, stop. You see? To the to whom? Who will be
Inspector General Shillong, madam.
Is he party here? Is he a party?
number 5 will do. DIG. With response number 5 will do. Malad. Deputy Inspector General BSF, Frontier Headquarters.
If he's not, then we'll just say, you say Inspector General of Police, Inspector General of BSF. Who should be appropriate authority, according to you? If he's not responded, also no problem, Dr. Majika.
Just for intimation.
The DIG sector headquarters, Tura.
He will be here, available here. No, he's travel pen, where he should communicate.
Because he's lodged in William Nagar jail. Tura jail.
No, but then his travel pen, if he has to inform to BSF authority here, to whom he should do it.
Well, he can inform to the IG BSF Shillong, my lord, or to DIG BSF Tura. Any one of them will do it.
Achha. So that DIG BSF Tura is for more convenient. Isn't it?
Yes, my lord. Just put it forward.
Okay, what we said? Travel plan. To the responsibility authority, namely, just say responsibility, namely, the
Deputy Inspector
General, BSF, Tura, or we'll just give the order.
Or to the Inspector General.
Or the Inspector General.
Frontier
BSF,
Headquarters, Shillong.
Inspector General, Frontier
Headquarters.
Headquarters, sir.
BSF Shillong.
If got correctly, there should not be any mistake. So, it is also provided that petitioner shall ensure his return within 10 days of the release, and the connected stand of his return, give a stop. The connected criminal appeal would be taken up we should miss this thing. You want that I should file an affidavit for this on his
either file an affidavit or report to the DIG on his return in Tura.
Report. Just see last name. Only after petitioner we return and surrender back to the custody. That is all right? Yes, no.
I think that is already come. The report will be heard after.
There may be just change of 1 2 words. That could be
what you mentioned criminal appeal, it's a criminal writ petition.
Sorry, criminal writ petition. Okay, last part. Stop. The applicant stands allowed. Yes, all right. And the criminal appeal. This matter after 2 weeks. This is coming after 2 weeks. After 2 weeks. Do not misuse the liberty.
No, that will not happen. Very grateful, though. Very much obliged.
There's nothing else. There was no other option, Dr. Majika. You see, in such a situation, probably there is a last thing. So like, if it is refused, also if something goes wrong, that will not go good.